course, my workers' compensation
Everybody loves Jeff.
buddy. And Jeff and I represented some folks along the way together in joint claims that ended up being multi-million-dollar claims. And they're interesting not only because they were valuable and extraordinarily complex claims, but these are nice people who, while working, got involved in nasty accidents, and they brought a claim both against their employer, bada bing, bada boom, against their employer and also against the at-fault party. So they were interesting claims, and I think you'll find it interesting. Of course, we're going to take questions from the studio audience.
What about the giveaways?
Oh, yeah, well,
you have the best prizes.
We do have the best prizes in all of radio. These aren't those stupid tickets to concerts that some radio stations offer up. Silence in the studio. What are you doing, Dean? You're talking talking crap against our employer. No, listen. I mean, that's fine. They give their little concert tickets away, but Dean gives hard cash and real significant, valuable product out. And so, Dean at My Philly Lawyer, I'll get you tickets. Don't worry, you'll be here. We'll hang out together, and that's on October the 25th.
Yeah,
all right. We have a studio guest today. I'm not sure. I don't believe he's been on the show before. Nope. And his name is Mark Cardos. Welcome to Court Radio, sir.
Thank you.
You want to talk right into that mic, Mark? Get friendly with it like it's maybe your best friend. There you go. Keep going. A little bit closer. Mark is an attorney in Philadelphia that My Philly Lawyer has referred much work to in a very specific area that not many attorneys, you can find an attorney that does a car accident on every corner. I mean, they don't do it as well as we do, but they're out there.
Every corner?
Every corner. Yeah, even at 8th and Butler. I mean, every corner in Philadelphia.
Car accidents, slip and falls.
Yeah,
you name it.
But Mark does an area of the law which attorneys run from. You say that, this type of case to them, and they go, huh? And they like deer in the headlights. They want nothing to do with it. And Mark has saddled up, and he's gotten himself an area that is underserved.
Niche.
You found a great niche.
Yeah. Dental malpractice. And actually, Mark shared with me that we referred him, My Philly Lawyer referred him a case that ended up settling for $200,000. And this is, I'm telling you, it's an area that most folks think they have a claim, but don't. Give me the first of all, how long have you been doing this, Mark?
49 years.
He told me that. He said that in an email or something to me, and I was shocked. I mean, you would think he'd be coming in here with walkers and back braces, and he's a spry guy. He's got the little ponytail thing going. He's like he came right out of the concert tour.
Like a Grateful Dead type of dude, right?
Yeah.
2 lobotomies.
So for almost 50 years, 5 decades at the bar of the court.
Been paying the bills.
Yeah. So tell us, Mark, dental malpractice. What makes up a dental malpractice claim that would be interesting to you?
Well, I guess starting off with what would not kind of be a dental malpractice case. Generally, if the patient is not satisfied with maybe the shape of new teeth or the color of new teeth, that generally is not going to qualify as a dental malpractice case. A lot of times people will get infections that generally are treatable. That's probably not going to make it either. And some people are just impatient after a few months, maybe half a year of treatment. They're not really happy with things. That probably is going to be too early to assess the case. It's going to take longer and see what develops, if there's any permanent problems, or if they can be treated. Generally, to start a dental malpractice case, it does get complicated, it does get expensive. in every dental malpractice case, you must retain an expert, which would be a dentist, and this dentist has to be critical of the defendant or the dentist that is going to be sued. So, it's not something that can be taken lightly, but generally most of the cases now have to involve with treatment of implants. Implants has become very common beginning maybe in the mid-90s. And, you know, prior to that, most of the treatment would be either dentures or bridges. Not really much that can go wrong. But with implants, it's invasive. It involves surgery. It involves, you know, putting screws into your jaw. And then after a certain amount of time, adding crowns to it. So most of the cases now that are viable and are successful generally have to do with implants and a bad result, maybe a raging infection, maybe repeat surgeries. Maybe the implants should not have been recommended even to begin with because of the person's poor dental condition or just not enough jawbone density to tolerate the implants.
What if, like, the dentist goes in and takes out a tooth thinking it's a bad tooth, but he's taken out the wrong tooth, and he's taken out a healthy tooth, and that can be, nowadays, as you just said, can be solved by getting an implant. Is the removal of a tooth that should not have been taken out something that rises to the level of a dental malpractice claim?
That would. Not very common. Dentists generally are very competent, very well trained, very passionate, do the best they can for their patients. But on occasion, a wrong tooth could be extracted. It could be that an adjoining tooth had been extracted and the dentist just really didn't count properly. So in those situations, yes, it can be taken care of with a implant, but that would be a strong case. If a tooth was extracted that should not have been extracted because of a misdiagnosis or not reading the x-rays correct, that is almost guaranteed a viable case. So much so that the dentist and the insurance company probably would not even contest that. They would agree to settle, which is very unusual because in dental malpractice cases and in all medical malpractice cases, they very rarely settle. The reason being that the insurance company, the medical malpractice insurance company for doctors or dentists, cannot settle a case unless the dentist or the doctor gives consent. And they generally will not give consent because if they do, it'll go into a data bank, and generally the public can see that this dentist or doctor gave consent to a settle, which is an admission of malpractice. That's number one. Number two, generally it will cause an increase in premiums for the malpractice insurance company if there is a case with consent. So generally, dentists and doctors will not consent to a settlement. They'd rather go to court. There's nothing to lose. If they lose, they're in the same spot they'd be in if they settled. And if they win, then they're back to zero. However, if a wrong tooth is extracted, that is a case where almost in every instance, the dentist will consent.
Do you have to get a certificate of merit? And what I want, we've gone over this in medical malpractice, but what is a certificate of merit and how do you get one? And is it a requirement to bring a claim?
Yes, and that's a very good question. That's what I was getting into before, that when you take on a dental malpractice case, it is complicated and it is costly because you have to hire an expert. Sometimes in a car accident case or a slip and fall case, you don't necessarily need an expert, but in all malpractice cases you do, and you have to prove that you have an expert when you file the lawsuit with what Dean just mentioned, a certificate of merit. A certificate of merit is a letter signed by an expert, whether it's a dentist in a dental malpractice case or a cardiologist in a medical malpractice case. The expert has to sign a form saying, I've reviewed this case and I have opinions on two things. One, the dentist or doctor committed malpractice, and number two, the malpractice is what's caused all of the patient's problems. So it does get expensive, and it is required. What's interesting is in 2002, Pennsylvania passed what is called the MCARE Act, which applies to all medical doctors that if they are going to be sued, a certificate of merit is necessary. That law did not include dentists for some reason. I think they were just more concerned with cutting rates for medical malpractice cases. Dental malpractice was not a big issue. If you remember back in the early 2000s, doctors were leaving the state, the premiums were so high. So this MCARE Act was tried to mitigate all these claims by requiring the plaintiffs to hire experts. It did not cover dental cases, but then Pennsylvania had another rule, a rule of civil procedure, which said that in dental cases, you also have to have a certificate of merit. What's also interesting about that rule, because it's not part of the MCARE Act, is it applies to all professionals. So based upon this rule of procedure, which was passed about 20 years ago, anytime you're suing a professional, you must have a certificate of merit. So if you're suing an accountant, if you're suing an engineer, if you're suing an architect, they are professionals. You must have a certificate of merit before you can sue them. So if somebody does work on your house and you're not happy with it and you paid them $40,000, if you're going to sue that builder, you have to hire another builder who qualifies as an expert, and he has to give a report saying this building was done improperly, and because of that, the roof is falling in or the roof is leaking. In other words, there's negligence and cause. So this certificate of merit now also applies in dental malpractice cases. You need that certificate before you can file the lawsuit, or most likely the case will be dismissed.
You know, we've talked about bringing a lawsuit in Philadelphia as being the best scenario or best venue to bring a case. If your dentist does business in, he has several offices, and he does business in, let's say, Bucks County, Montgomery County, Philadelphia County, you had your claim, you had your treatment in one of the collar counties to Philadelphia, but there is an office that the dentist maintains in Philadelphia. Can you bring that claim in Philly?
Another good question. Now you can. Philadelphia is definitely the best venue for plaintiffs to sue in, whether it's malpractice or pretty much any kind of litigation. Philadelphia is known as kind of the capital for plaintiff litigation in the country. So LA might be music, New York might be finances, but with Philadelphia, we have the proud distinction of really being the best place for litigation. Examples of this are the asbestos cases back in the 80s when asbestos was causing cancer. They really could have been filed anywhere in the country, but they chose Philadelphia for most of the cases. Same thing with the NFL litigation for the traumatic brain injuries. Those cases could have been filed anywhere where there's a NFL team. So they could have been filed in Chicago, New York, LA. Those cases pretty much were all filed in Philadelphia, and probably a good choice because the Philadelphia system took over and resolved much of those issues. They're still being worked out and appealed, but yes, Philadelphia is the best venue. The surrounding counties, Bucks County, Montgomery County, are kind of known to not be plaintiff-friendly, pretty much in all personal injury cases, but particularly medical malpractice cases. So, as Dean was alluding to, can you sue in Philadelphia if the treatment by the dentist was in Norristown or Media? It's a good question because now you can. When this 2002 MCARE Act was passed, it specifically stated that you could no longer sue in Philadelphia unless the treatment was in Philadelphia. The surgery or diagnoses were made in Philadelphia. If the treatment was somewhere outside of Philadelphia, you could not move venue to Philadelphia. And in 2002, when that was passed, cases filed in Philadelphia dropped by about 70%. But a year ago, the law changed, and now you can sue in Philadelphia even if the treatment did not happen in Philadelphia. It's really a game changer.
So long as the medical facility has some connection to Philadelphia.
Exactly. So after 2002, when they passed the MCARE Act, you could not sue in Philadelphia, even if well, for example, suppose you're suing the Rothman Institute, a fine facility. Of course, sometimes they could make mistakes like anybody else. But if you had Rothman surgery in Norristown after 2002, you could only sue in Montgomery County. And a lot of firms would not take cases if that was going to be the situation. About a year ago, this all changed, and now you can sue anywhere as long as that defendant has some kind of operations in the county that you want to sue. So if you wanted to sue the Rothman Institute for a surgery that happened in Chester, you could sue them in Philadelphia County because the Rothman Institute has offices in Philadelphia County. If you were going to sue a Dr. Joe Smith, who just is a sole practitioner orthopedic practice in Chester County, you would not be able to sue him in Philadelphia County. He probably has no connection there. So in answer to your question, Dean, about dental malpractice cases, if your treatment happened in Norristown for a dental malpractice case, and you were suing a kind of like a small office or a sole practitioner who only works in that county, you would not be able to sue in Philadelphia, which is optimum. However, if you're suing one of the bigger practices who have franchises and operate in several counties, such as Aspen Dental, they're in pretty much all the counties, cities, or Clear Choice. They advertise on television, and again, they have offices everywhere. So as of 2023, if you have a dental malpractice case against Aspen, Clear Choice, or one of the chain types, and the incident did not happen in Philadelphia County, you can still sue in Philadelphia County.
215-227-2727. Give us a call. Have you experienced a dental mishap that you thought, I'm going to get this dentist? Manuel?
Now, you know what comes to mind right away?
What's
Just right away.
Yeah.
Philadelphia Flyers win the Stanley Cup in 1972. The parade happens in Philadelphia on Broad Street. A kid is standing behind a Philly, what's the name horse? What do they call them? The department that they ride they ride the horses.
Yeah, police horse.
But there's a name for them. Anyway, he's standing behind them.
Mounted?
The mounted, whatever. He's standing behind them. The horse gets excited and kicks him right square in the mouth, knocks all his teeth out.
Yeah, that.
And I wondered, whatever happened to that kid? Who sues who? Who was his attorney? What's
that
his
would have
mouth
been a
like
claim against the horse.
yeah. Philly
Yeah.
police,
Well, Philly
PD.
police.
Yeah.
Like the horse doesn't have any assets.
He's
may
got
have a
an
big
ass.
He may have a big asset.
But
Wow, you guys couldn't help yourselves.
but
that just came to mind. I mean, because I don't think about dental malpractice. Then he started talking about Clear Choice and all the veneers now. and
I have a
everything.
claim right now where there was a fellow who was he is a policeman in New Jersey who is involved in a car accident, and it was a bad wreck, and he lost the front 3 teeth in his mouth as a result. Now, of course, I submit the claim and I make my demands, and the insurance company said, his teeth were rotten anyway.
Oh,
You
wow.
know, so
They was doing his mouth.
yeah, well, it was just a matter of a few moments before those chiclets were going to fall out anyway. So we're not all that impressed with that claim. Of course, it's going into suit because that's what has to happen.
I have a question. If
The floor recognizes tactics.
tactics,
Mr. Jackson?
yep,
Yeah.
for recognition. If you have an accident after anesthesia,
Yes.
is that something that goes back to the
It's
dentist?
a great question, and oftentimes he asks the right ones. See, to me, the big claims on dental malpractice are claims that are systemic. So you go to the dentist, he dopes you up, and you're in the chair, and your heart rate drops, and you code, and he's not prepared to handle that, and you end up dying in the dental chair because of some medicine or treatment rendered by the dentist that day that had a really nefarious effect on your body. Is that a claim against the dentist?
That probably would be, and of course it would have potential to be a very substantial value claim if the person dies and the person was young, left a family. Maybe
And in speaking in those terms, maybe you get an infection, the dentist doesn't recognize it, doesn't treat it. The infection becomes a systemic blood-borne infection, and you decompensate and eventually pass away. Again, these are the types of dental malpractice claims that I would think somebody would be like, yeah, I want that one.
Yeah, that certainly would be. The dental malpractice cases are not quite as common as the medical malpractice cases because the medical malpractice cases could involve fatalities, paralysis, permanent disability from work, so they really have potential to be substantial. Most of the dental malpractice cases do not have that value. Very rarely there's a cause of fatality or permanent disability. Most of the conditions are treatable. However, a lot of pain and suffering during the treatment and a lot of expenses. But in your scenario, in that case, you would need two experts. You would need two certificates of merit. You would need first you would need a dental expert to go against that dentist, and he would have to come up with an opinion that this anesthesia should not have been used because it was known in the records this person could not tolerate it, or
he used too much of it, or whatever. So the dentist did something wrong, and then that something caused the demise of the patient.
yes,
That goes beyond dental malpractice.
yeah, because then you would need a causation expert. So in every certificate of merit, you need two opinions. The experts have to give an opinion that there was negligence, this was not the proper anesthesia, or this person was not appropriate for it. And then you need the second opinion, and that's what is called the causation opinion. So, for example, if a doctor, we'll go to medical malpractice, a doctor misdiagnoses a type of cancer that is not aggressive, maybe breast cancer or prostate cancer, in some cases is not aggressive. If a doctor misdiagnoses that and then it's properly diagnosed 6 months later, that may not be a case because there may not be any harm from that. In 6 months, the delay does not really cause any additional problems. However, if a doctor misdiagnoses liver cancer or bladder cancer, two of the much more aggressive cancers, and a 6-month or 9-month delay wipes out any chance of recovery, then that is a strong case. You have negligence, and then you have causation. So in Dean's scenario, the dentist does not properly anesthetize the patient, and the patient dies. You first need an expert dentist to say that was negligent, that anesthesia should not have been applied. But then you need the second opinion, and that most likely will be an expert anesthesiologist. And that expert will say this anesthesia is what caused the death of the patient. In other words, the patient didn't just coincidentally have a seizure on the table or a heart attack or a stroke. No. death was caused directly by the anesthesiologist. And you may even have a third expert, and that would be a pathologist or a coroner who would do an autopsy and say, from the labs, yes, this is what caused the death. The anesthesia, not a stroke, not a heart attack.
Let me tell you something. What we just went through, what you just reiterated, is the downfall and death of so many plaintiffs' attorneys who claim to be malpractice attorneys, but really aren't. And if you're going to muck around in this area of the law, you really need to understand what Mark just said, because most attorneys, they look at what the malpractice was, but never bother to figure out the causation. And they're sitting in front of a panel of 12 jurors as they get their butt handed to them by a defense attorney who never worried about the malpractice at all. He or she was focused on causation. And if you don't prove the causation, you don't have a case. We are going to be back in 2 minutes after my sponsors have their way with you. But if you've got a legal issue, and Christina, stay on the line. If you got a legal issue, we got the answer. 215-227-2727. Up. Okay, we're live and in the studio with our YouTube followers. Guys, I really appreciate you. Remember, like and subscribe. Who's on the line, Dion?
I'm trying to get you closer to the mic.
Okay.
So you have to like be, yeah.
I need you to be.
Obviously, I'm a newbie.
Stay right there.
Like this?
Yeah, don't
Okay.
Yeah.
Like I tried to direction it, and it was a little bit better, but
Wait, where am I going? What am I doing? Sorry.
So I can do one of two things. Either keep recording on RNB Philly and upload the whole thing on your show, or we can just record the second half of your show. I think we just record the second half of your show. Do you mind if I see the password so we don't have this issue again?
now, Dean, after the break, right?